Well, Your Honor, I swear I'm not trying to take the kids away. Hi, my name is Carl Birkhead. I'm an attorney with Worth Law Office in Tulsa, Oklahoma. I've been practicing family and criminal law for 8 years now, and I want to talk a little bit about when certain things that you're trying to say can backfire on you, specifically when it comes to withholding custody and visitation. So, I can't tell you how many cases I have where I'll have clients that just have every reason that you can think of for why their children should not be with their other parent. Some are justifiable, some are not. And guys, I'm not trying to throw shade or cast aspersions on any of my clients or any parent that's in a custody situation. These are really, really high stress, really like anxiety driving things. But certain times I'll get a parent who, for whatever reason, they're just adamant that, well, they're not trying to take the kids away or they're not trying to keep the kids from the other parent, but they just have concerns. There's just a few issues that really they make them feel that it's not good to send the child over there. You've got to be able to articulate these things. So under Title 43, yes, 43. Wow, I just had a brain blink for a second there. Under Title 43, there are specific provisions for when and how you can withhold visitation. If you believe that your child is going to suffer from irreparable harm, like suffer from abuse and neglect, you can suspend visitation based off of that. It's a thing. It happens all the time. But you have to be able to justify it. What that means is you can't just say, oh, well, I'm feeling a disturbance in the force, so I don't think we're going to do visitation this weekend. Or, my spidey senses are tingling. Sorry, just visits are going to be out. That's not enough. You have to be able to articulate in a meaningful way and really honestly back it up with evidence why you're not why you're not sending the kids. Because otherwise, yeah, you are taking the kids away. Regardless of what you say you're trying or not trying to do, that's the effect, is you're withholding the kids with arguably no justification. So you have to be able to back it up. It can't just be that you have a bad feeling. You have to be able to describe specifically with examples why. What behavior are you seeing? Are the kids coming back dirty? Are they coming back with lice in their hair? Are they coming back with tales of like abuse or wild fornication parties or drugs being used in the home, something like that? I had a case, oh, this was years ago, where my client, who unfortunately she wasn't my client for very long, but she decided that she wasn't going to send the child for visitation because the child just got so anxious and so worried before each visit that she couldn't possibly send that child back to their father when they were just so visibly upset. That child was 9 months old. It was a baby. Couldn't tell her. There was no proof that anything was going on in dad's home. There was no, I mean, DHS investigated, they found nothing. Drug tests, they found nothing. Like, there was no actual proof that anything was wrong. But for whatever reason, she was just convinced that the world would end if the child was sent to dad's home for visitation and kept refusing because of that. But she wasn't trying to take the kid away. She was just trying to keep the kid safe. Unfortunately, though, you can say that all you want, but if your actions look like you're trying to take the child away, you can't justify it with an actual measurable, articulable reason. The court's not going to see it that way. And guys, that is dangerous because if it looks like you're interfering with the parent-child relationship, you can lose custody entirely. If you have questions about this, give me a call. This is very important. It's very serious. So you need to make sure that you're doing this the correct way with the advice of counsel. My name is Carl Birkhead. I'm an attorney with Worth Law Office, and I want to help you make law easy. Thank you.